Hi, everyone, and welcome to this week's live edition of our Immigration Question webinar series, your trusted source for the latest immigration updates, expert legal insight, and live conversations with licensed attorneys. My name is Anasia Mukherjee, and I'll be your host for today's session Remote Work Considerations for Temporary Visa Holders, Compliance Issues. In the past few years, remote work has reshaped the way we think about jobs. But if you're in the US on a temporary visa, like the F1, OPT, CPT, H1B, L1, or O1, working from anywhere isn't always as simple as it sounds. Whether you're logging in from your apartment, a different state, or even another country, compliance matters. If you're not aware of how remote work impacts your visa status, you could unintentionally fall out of status, delay your green card process, or even face future denials. That's why today's session is so important. We're here to break it down in plain English so you can protect your legal status and while enjoying the flexibility of remote work. Today, we're joined by attorney Funmi Uke, an outstanding immigration attorney based in Fort Worth, Texas. She has a powerful track record of helping individuals and families navigate some of the most complex immigration issues out there. She's fluent in Spanish and French, and her deep knowledge of immigration and international law makes her an essential voice on today's topic. Thank you so much, Attorney Uke, for joining us today. We're thrilled to have you on the show.
Thanks for having me.
Thank you. Before we get started, just a quick reminder Immigration Question is a platform that connects users to licensed immigration attorneys. We are not a law firm. All legal services are provided independently by attorneys registered in our network. Let's dive right in. Attorney Uke, remote work has exploded in popularity since the pandemic, but for temporary visa holders, there are unique compliance risks. What are the key immigration compliance concerns for temporary visa holders who want to work remotely in the US?
Yeah, so once again, I want to reiterate my gratitude for being on here. I really appreciate you all having me. So a lot of key considerations really um, are really informed by your visa type. So a lot of so let's just look at the temporary visa types, the L's, the H1Bs, the O1 visas. A lot of them have their own specific stipulations as it relates to the type of visa that you hold. So, for example, if you're on an H1B visa, something to consider is how the wage that is set by that which is or your prevailing wage, the wage that is set by the Department of Labor that the your employer is meant to pay you on an H-1B visa is determined by your location. So it's very location specific. So, for example, if your job is in Atlanta and your employer files a prevailing wage determination for Atlanta, that means that you are required to work in Atlanta and only Atlanta unless you now apply to the United States USCIS basically or Department of Labor for another prevailing wage determination for a different location. So that's a key consideration that a lot of visa types are location specific when it comes to the or basically location specific when it comes to where you want to work because of how the different wages are location specific. So
Okay, thank you for breaking that down. Now, when people think about remote work, they often assume if I'm still working for the same company, it's fine. But that's not always true under immigration law. Are remote work arrangements allowed under visa types like H1B, L1, or O1? And what are the limitations?
do you mind repeating the assumption again? That what was the assumption? The first assumption?
The first assumption is if I'm still working for the same company, it's fine.
And if they're still working for the same company and it's remote, or they just it doesn't? Is that the assumption that
If it's still
even if
remote,
I'm working for the same?
yeah.
Okay, yeah. So that's definitely an assumption that is incorrect. So basically, the way that it works is that USCIS over the past few years has had to catch up to different trends and or the change in the job market and how a lot of companies have become more flexible when it comes to their working arrangements. So some companies have had different models as it relates to hybrid working models or fully remote working models. And of course, we have had some companies in recent times, as recent as the past 6 months, change to a fully back in office, so fully on site job or role model, as you will. So so because of that, because we have so many different working styles now as set by companies, USCIS has had to catch up to that. And how did they catch up to that? They basically have created more guidance on which how will our visa types accommodate for remote workers. So for many of these different visa types, they still have the stipulation that if you are working remote, you still need to indicate your home as your job site on our applications. Simple as that. So it's not it's definitely unsafe if you are working from home and you have not told USCIS based through your application that you are working with your company when you're working from home. So essentially, if let's just say you're working fully on site with your company and your company has now changed to a either a hybrid or a fully remote model, and for every foreign worker, your employer has to now file an amendment to tell USCIS that, hey, this work site has changed, or we have added a new work site if it's a hybrid model, saying this is now the foreign worker's new work site, which is your home address. So even if you're working from home, you have to indicate this or share this with USCIS so that you can remain compliant, or you and your employer can remain compliant.
All right, thank you for that. That brings us to another
Mhm.
really important point: location changes. A lot of people don't realize that where you work physically matters. How does a change in work location, such as moving to another city or working from home, affect a visa holder status?
Yeah, that's a great question. So when it comes to changing work locations, if your job transfers you to a different city for work, or as we kind of briefly mentioned before, your job changes their work arrangements, where from a fully remote model to a hybrid model, or vice versa, you are still. It's essentially just a procedural activity of updating the records with USCIS through filing an amendment. So it doesn't necessarily change your status. It does change what you are required to report to USCIS in terms of filing an amendment. So in some cases, you may see fluctuations in prevailing wage rates based on where you're being transferred to. So let's say you're initially working in Florida,
Mhm,
and your job now transfers you to Minnesota, to
mhm,
the company, to the branch in Minnesota. You might, and this is just on the back end, your when your company files an LCA, which is a labor condition application, they might see a change in the prevailing wage range. It may not be or excuse me, prevailing wage rates. It may not be a total change because across the board, the prevailing wage rates tend to be similar,
mhm,
but it may be a change. And these prevailing wage rates are very job specific. So for a software engineer, you may see the hour. Let's just use hourly as a standard. So an hourly rate of $90 for the prevailing wage for a software engineer in Florida may be different to the hourly wage for software engineers in Minneapolis,
mhm,
which might be now $80 an hour. So again, that is why you know we're emphasizing the importance of you and your employer remaining compliant with H-1B visa rules to share these location changes with your employer because of how much it's tied to the wage rates as set by different locations,
mhm.
and that's essentially why it's so important because of how they're so interlinked or intertwined that USCIS and DOL really want to know or really want to be kept up to date so that all companies are being compliant with how much they're meant to be paying their workers.
Great. Thank you for that. Great insight. Let's talk about best practices. What steps should employers and employees take to stay compliant with USCIS and the Department of Labor requirements when remote work is involved?
So, sorry, can you repeat the question one more time?
No worries. It's basically what steps should employers and employees take to stay compliant with USCIS and the Department of Labor's requirements when remote work is involved?
Yeah. So the steps that they can take are very much working hand in hand with their HR departments to ensure that they have up to date records. So from the LCAs that are on record, I mean, one, let's just actually stay on the idea of having up to date records. That's very, very important for having a great record or having great record keeping of all documents or having all documents already ready for any unexpected check-ins is very important, especially in this current administration. That is where we are seeing an uptick in the amount of audits. So we're seeing a lot of more site visits from USCIS and Department of Homeland Security officials on employers randomly. So they're doing random checks. So it's very important to have all your records ready to go for in case of any site visit, in case of any audit from the Department of Labor or from USCIS. So this is very important. And then also, in addition to that, it's also very important to have to do regular checks of said documents. So making sure that the documents are accurate at any given time and are on par with any changes in company policy. So let's just say there's a new change, as we've kind of discussed before, in working style models. So let's just say the company has now changed to a fully remote work style, or they're moving in the process of moving employees to a different branch. All of these um, all of this means that the HR team has to now review the foreign worker documents to ensure that these documents are up to date with such changes. So and if they're not, they need to now make the necessary or take the necessary changes or make to all the documents are up to date. So whether it means to file an amendment, whether it means to file a new labor condition application, or if it just means something as simple as informing USCIS of an address change, all of these things need
Mhm.
to happen so that companies can remain compliant and employees as well can remain compliant with USCIS laws.
All right, thank you. Now, immigration policy is always evolving. Are there any recent updates or policy changes regarding remote work for visa holders that people should be aware of?
Yeah. So right now, when it comes to remote work, there hasn't been any as much, or if any. The only thing is ensuring that companies are documenting the work sites on USCIS, or excuse me, on the applications. So this was a new regulation that was set in 2021 or 2022, which is like the aftermath of COVID, if you will, where a lot more companies have introduced a remote work style engagement with their employees. So with that, this 2021/2022 regulation has seen now this requirement that um, companies list the home address of the employee as a work site in the event that they're conducting any kind of business at home. So even if it's just one day at home, they need to list it as home as the work site, as a secondary work site. So that's something that employers and employees need to know, that even if it's just a one day from home or 2 days from home, 3 days in office, the home address needs to be listed as a work site.
All right. Thank you for that. To our amazing audience, thank you for joining us. Whether you're tuning in from Facebook, YouTube, or LinkedIn, we're thrilled to have you here. We are immigrationquestion.com. a two-in-one platform built with lead and case management to help simplify the process. Though we are not affiliated with AILA, we are trusted by a lot of AILA attorneys who use our platform. You can also ask your immigration questions for free in any language and get connected with the licensed attorney for guidance. You may also receive a free confidential initial consultation. Just visit www.immigrationquestion.com and sign up today. And some exciting news, we've just launched our new app built to serve both attorneys and users seamlessly. Now, Attorney Uke, as a licensed legal professional working closely with both documented and undocumented immigrants, how do you view the role of platforms like immigrationquestion.com in supporting and empowering the immigrant community today? And in what ways do you think it adds value to individuals seeking legal guidance and trustworthy information?
That's a great question. I believe that when it comes to immigration and immigrants needing assistance, I believe there's an access issue. So when I say there's an access issue, I believe that we have a lot of red tape when it comes, and it may not necessarily be red tape set up by immigration attorneys, but just red tape as in general, as in regards to USCIS, getting through to USCIS, getting through to any agency for assistance, both on the family-based immigration and on the employment-based immigration side. So, and even like when I discuss red tape, I also want to include red tape on the side of the immigration attorney themselves, because um, immigration attorneys are few and far between. We do make up a good number of attorneys within the space, but we also do recognize how much workload we have as professionals, and we're pretty much just one person, or one person with a team of people, but we may not be able to get through to every question as it may come as it comes, and understanding that many immigrants have a pressing need to get their questions answered as soon as possible due to the time constraints, due to the urgency of their question. It's very important to have platforms like Immigration Question that provide this seamless opportunity to get through to any attorney or to an attorney as soon as possible, or in the way in which the platforms are set up. So I think that is very essential, just given the fact that there is a kind of an access issue that platforms such as Immigration Question are working to solve. So.
Thank you. So before we take live questions from our audience, we know that compliance is clearly a big deal here. So what happens if you get it wrong, right? Like, what are the risks for non-compliance when it comes to remote work? Can it lead to denial of visa extensions, audits, or even state violations?
Yes, all of the above, actually. So, when it comes to when you get it wrong, or if you get it wrong, this is why we stress the importance of good record keeping, of staying up to date, of just really ensuring that you have someone on your team as an employer who is very, very knowledgeable about immigration laws and procedure. Because if you do get it wrong, there's a lot of consequence, and there's not enough opportunity for um, let's say, for getting it right. USCIS can be very strict, as even as strict as, oh, you didn't indicate this, but you said this. Okay, I'm sorry. So things like that, where we see a lot of pushback just on a very minor technical error. So because of that, it's very the consequences are, we can see something as small as a fine on the side of the employer, or as big as a visa revocation on the side of the employee. So these are things that show the gravity of the matter, in the sense that both employer and employee do face heavy consequences for not being in compliance with immigration laws. Because on the side of the employee, that visa revocation means a disruption to their economic standard of living, and also disruption to their life altogether in the country that they're temporarily working in. And then on the side of the employer, business disruptions, because that person was very critical, most likely was very critical to, or the whole application showed that the whole visa application showed that the critical nature of the person to the job. So in essence, we see how critical the person is and how much it's important to keep them on the job to keep things going in the business. And if they don't have that, the turnover to find someone new is hard, because that's the whole reason why USCIS approved you to hire a foreign worker in the first place, um, because of the gap in the job market based on all these things that we're seeing in our current job market right now. So all these things, business disruption and also disruption to the person's livelihood, are really really big consequences that should be taken seriously and show the reason to remain compliant at all times with USCIS laws.
Definitely. That was insightful, Attorney Uke. To our audience, the floor is now open. Drop your questions in the chat, and Attorney Uke will answer as many as possible. If you'd like to call us live and ask directly, dial 516-703-3483. So our first question is, my employer wants me to switch to full-time remote. What should I update in my SEVP portal?
Okay. So if your employer wants you to switch to full-time remotes, it's very important to indicate that the job setup is going to be fully remote, and then now indicate the address and that will be your work site essentially. So you're going to put that in the SEVP portal, and then you will also need to include a letter from your HR department or relevant authority within the business to support this statement that this is going to be a fully remote position, but with the caveat that the remote position has a specific work site attached to it from where you will be working at all times. So,
All right, thank you. Our next question is, I've been working from home, but my I-983 still shows the old office address. Is my status at risk?
so I wouldn't say your status is at risk per se. I would say that it is something that you would need to notify USCIS or the relevant authority at all at as soon as you can, because you and your employer may face a compliance issue, but your status is not necessarily at risk if you were able to share the reason why your I-983 still shows the old office address, and there's been a change. And if there's an audit, like let's just say tomorrow there's an audit and you all haven't provided the update, you will most likely just need to explain to the officer, whoever that does the audit, that this is why this was not done in a timely manner. But I don't want you to think that this automatically means your status will be revoked. So it's a matter of just providing an explanation. But if you can right now, get on top of it to go ahead and work with the HR team or work with the relevant authority within your organization to make the change as soon as possible.
Thank you. Our next question is, I'm on a B2 visa visiting my kids. Can I still do my freelance work for my non-US clients from here?
That's a very good question. As long as you're not doing work with a U.S. organization or for U.S. Citizens, you are still clear to engage in or conduct business for your non-U.S. citizen clients or non-U.S. based clients altogether. So and I want to just believe that your company is registered in a foreign entity abroad or in a foreign country abroad. So if that's the case, then yes, you can still engage in freelance work for your non-U.S. clients um, from the U.S. Let's just say you have this, you're working with your computer and you have your clients' information on your computer and their non-U.S. clients. Yes, that's very much allowed on a B2 visa as long as you're not engaging, because the B2 visa provides that restriction that you cannot engage in you work for a U.S. entity, for a U.S. employer, for U.S. citizens, let's say you want to set up a business on a US based business on a B2 visa is not allowed. So as long as it has um, no kind of imprint that essentially ties you to the US, or has any engagements with um, entities within the US, you should be fine.
All right. Thank you. Our next question is, I'm freelancing for foreign clients while visiting on a tourist visa. Is that allowed? So basically the same question.
Yes.
So I would say yes. The next question is, I need to go home for a few months, but I want to keep working remotely. Will that affect my OPT?
That's a great question. It was actually on my presentation. Yes, it will. So, one of the things that I do a lot of looking at posts or engaging in posts on LinkedIn, and then one of the attorneys shared that their client was at risk of losing their STEM OPT based on this specific kind of scenario. So the person got a got a job essentially on OPT, and they started working remotely, or the job is remote essentially. So they decided, since the job is remote, they can go abroad and work with do engage in work activities for their employer abroad. So they went to countries like Japan, India, more or less taking advantage of the fact that the job is remote, which is, awesome, because, the job is remote. And especially if your employer doesn't have any restrictions to where you can work from, that's even better. But in this case, his OPT did provide that restriction. The employer didn't provide the restriction, but his OPT does. And essentially, the restriction was set up is that when the person came back into the country, they from the time that they left to go out to Japan and India to work from those places to the time they came back, they accrued 100 days outside of the United States. So USCIS counts time outside of the United States on OPT as unemployment time. So that's just their standard rule. Regardless of if you were employed or you weren't unemployed, they say any time outside of the US on OPT is unemployment time. So, and their rule is that if you spend more than 90 days outside of the US on unemployment or unemployment time, as they call it, you have forfeited your OPT status, because you can only spend up to 90 days unemployed on OPT. So this person, like I said, spent 100 days outside of the U.S. on OPT. So they basically gave them a notice of intent to deny, or revoke their OPT. Thankfully, that attorney was well versed, and she, was able to do some things, and basically look through and find some technicalities to help their client. But you never want to be in a position where the attorney has to now look for technicalities to help you, because it's a 50-50 chance. But thankfully, she was able to prevail and advocate for her client in this case, and he was able to stay on OPT. So the short answer to that long scenario is that it will affect your OPT. You should definitely consult an immigration attorney to discuss how long you will be working remotely outside of the country. So I'm assuming you're saying you need to go home for a few months, and that's outside of the country. That's typically not allowed, and if it's for more than 90 days, you are likely going to be in the danger of getting your OPT revoked.
All right. Thank you for that. Our next question is, I work for a US company remotely from Nigeria. Can I apply for a B1 visa to visit the team for a team retreat?
Okay, that's another great question. So it's possible. You would now need to get a cosign from your employer explaining the the technicalities, or the like the what the yeah, the nuances, or the specific things as relates to your visit. So it wouldn't just be you saying that, let's say on your DS 160 through the application, you now put this is the reason for your purpose of visit. You would need to provide a statement as well, supporting this from your company. that says this is why this it's essential for you. Maybe provide a reason that it helps with team bonding, that your team will be able to, be more productive. So anything that kind of helps your case. So it is one to answer your question. Yes, it is very much allowed, and two, to further help your your filing, you would definitely need a cosign from your company, saying that they are the ones authorizing this visit. This is a critical reason as to why they really want you to come for the retreat, and show show the veritability of the retreat, show the legitimacy of the retreat, and you should be fine.
Okay, thank you. Next question is remote unpaid internship counted as a valid employment under the OPT rules?
So when it comes to specific OPT rules, I'm not necessarily too well versed on that. I would like to believe that because remote work is allowed under OPT for a specific work site, that is allowed, but I'm not sure about the unpaid aspect of it. So you would need to contact your school DSO that issues the F1, which the OPT is tied to, for further questions about unpaid or versus paid internship and if that is allowed under OPT rules. But definitely the remote aspect, if it's remote tied to a specific work location, that is very much allowed.
All right. I think we have any more questions, or maybe I think that was our last one. That's our last question. So that was an insightful session. Thank you so much for joining us, and a special thank you to our special guest, Attorney Uke, for your practical and strategic insights. We hope this webinar helped answer your questions. Remember, at immigrationquestion.com, you can ask your immigration questions for free and get connected with a licensed attorney in good standing who can help you better understand your options. You may also qualify for a free confidential initial consultation. Visit our site to learn more. Don't forget, you can rewatch this session or listen to previous episodes on Spotify. Just search for Borderless Talk by immigrationquestion.com. Join us again on Friday for another enlightening edition regarding another burning immigration topic. Trust us, you won't want to miss it. Once again, Attorney Uke, thank you so much, and we look forward to having you back soon.
Thank you so much and have a great rest of your day.
You too. Bye bye.
Bye.